Hey everybody, this is my first YouTube video, so please bear with me. I got in trouble on the other platform and I've been blocked or removed for bad behavior, and I'm not quite sure what I did. I was trying to upload for hours yesterday a video. And I was trying to encourage people to start using some of the free services that are out there online for offenders, to see if a person has a criminal record, and also to look up the S offenders. Um, so I guess I got in trouble for that. So now I'm going to try to move forward here and see how this goes. So let's go. So, as I've been saying in some of my other videos, I've been wanting to do a video just to discuss some of what's been talked about with the Idaho 4 case and what's going on now, which there are some comparisons to a preliminary hearing versus the grand jury indictment, and what does all of that mean. And Brian Kohberger right now has to deal with his alibi and what's going on with that. So as always, I always want to give you some background, basic information, foundational information before we get started. So let's go. So I want to just let you know what a preliminary hearing is, what does it mean, and also about the grand jury. So I'm going to read right from my page, and you can follow along if you have that open. So a preliminary hearing. It's a criminal hearing usually conducted by a magistrate to determine whether there is sufficient evidence to prosecute an accused person. If sufficient evidence exists, the case will be set for trial or bound over for grand jury review, or an information will be filed in the trial court, also termed preliminary examination, probable cause hearing, bind over hearing, examination trial. So the preliminary hearing is set up, is scheduled. This is where the prosecution and the defense both appear. They both can present evidence. They both can cross-examine the witnesses. If the prosecution puts on a witness, the defense can then ask questions of that witness, and vice versa. If the defense puts on a witness, then the prosecution can go and cross-examine. And that's kind of a balanced approach. It kind of takes a lot of work because you have to schedule it. You have to get all the witnesses on board to come. You have to have a certain amount of evidence as the prosecutor to put forth to show that this case, by the standard of probable, if the standard is probable, not reasonable doubt, is, I can't think of the standard right now because my brain is everywhere, because I have such a hard time getting on, but it'll come to me. But the standard is lower. It's not beyond a reasonable doubt. You have to have probable cause. That is a lower standard that this person committed this offense. So a lot of states like the preliminary hearing because that gives some forthcoming of evidence, some forthcoming of witnesses on what will be said, and if there's determined to be enough evidence that this person committed this or these offenses, right? So people really like that balance. But it is a lot of work on the prosecutor. In Brian Kohberger's case, he was set to have his preliminary hearing in June, and a twist came up with the prosecution. In May, they revealed that they had presented before a grand jury and they indicted him through the grand jury process. So let's talk about that now, okay? If you're following along, or you can just be listening, you can check it out later. This is what Black's Law Dictionary has to say about a grand jury. It's a body of often 23 people who are chosen to sit permanently for at least a month and sometimes a year, and who in ex parte proceedings decide whether to issue indictments. If the grand jury decides that evidence is strong enough to hold a suspect for trial, it returns a bill of indictment, a true bill, charging the suspect with a specific crime, also termed accusing jury, presenting jury, or jury of indictment. Okay, so let's kind of take this apart a little bit. So the grand jury is going to consist of a certain number of people, right? And that certain number of people are going to come together for a period of time to listen to evidence and witnesses that are put forth. But in this case, this is only done with the prosecution. So the prosecution doesn't have to worry about the defense or cross-examining anyone. It's a lot less work to go this grand jury route because you don't have to deal with the defense at all. So let's define what ex parte means, because that was part of explaining the grand jury, right? So the word ex parte is Latin from the part. And if it's used as an adverb, this is what it's used as, and this is the meaning behind it. On or from one party only, usually without notice to or argument from the adverse party, the judge conducted the hearing ex parte. That's an example, okay? Now, if it's used as an adjective, if the word ex parte is used as an adjective, it's done or made at the instance and for the benefit of one party only, and without notice to or argument by any person adversely interested. An ex parte hearing, an ex parte injunction. So, to break it down in a simpler term, ex parte means that even though you have two parts, so you have the prosecution that's working on behalf of the state, and then you have the defense that's working and representing the accused. When you do an ex parte action, it's not going to include both. It's only going to include one or the other, but not both. Now, in this instance, when you go to a grand jury, the prosecution on behalf of the state is bringing in the evidence and the witnesses without that adverse party. The adverse party would be the defense, because they're going to bring opposing information. They want to disprove what's said. They may have their own witnesses, their own evidence, their own experts, right? Okay, so let's just break it down simple so we can follow along with what's been going on in Brian Kohberger's case in Idaho 4 situation. Now, another term that was used in the explanation for the grand jury is the word indictment, right? So let's just define that so we can all be clear about what we're talking about before we go there. This is the formal explanation for indictment. It's the formal written accusation of a crime made by a grand jury and presented to a court for prosecution against the accused person. The act or process of preparing or bringing forward such a formal written accusation. They also can call it the information, that is the written document that's going to detail what happened, or the presentment, okay? So indictment, information, presentment. So if I say, well, can you obtain the information? That's just the written form of what they're accusing that person of, the crime, the offense, what they believe happened. Okay. So now let's go back to just discuss the grand jury for a minute. So the grand jury is going to be made up of people. That grand jury can consist, in this instance, they're saying often 23 people. That's a lot of people, right? But every state may have a different number, so it could be smaller than that number, likely to bring 23 people together. So you're going to have this group of people, and the prosecution is going to be putting on evidence, witnesses, testimony, and that's all for them to make a determination with the probable cause standard, which is a lower standard, not reasonable doubt or beyond a reasonable doubt, is there enough evidence that you believe that a crime happened by this person? Okay, so let's keep going. Now, I want to discuss two things. I want to discuss the motion that the defense filed in the case, and then I also want to discuss an article that CNN released on the case, just discussing what's been going on. So we can break down the motion by the defense, and I shared it on the page so you can kind of follow along, or you can just listen to me read through the motion. So let's get started with the motion. So the motion is titled Objection to the State's Motion to Compel Motive of Defense of Alibi or Alternatively to Bar Certain Evidence. So I don't want to read everything. I want to move kind of through it. In here, now comes Brian Kohberger fighting through his attorney, and that's going to be Ann Taylor. She's representing him. So let's go. The review is underway. The defense had to obtain investigative materials from the state's investigative counterparts, the FBI, through an order compelling the state to provide such materials. The state made draft disclosures just 2 weeks ago. The sufficiency of these disclosures is currently being analyzed. So with this motion, the defense is pretty much saying that every piece of material that they need, the state is not willingly turning over the documents. They're having to go and get these documents, and they're being delayed. Now, this trial for Brian Kohberger is set for October the 2nd, so that's less than 2 months now. So I guess the defense is concerned, as anybody else, why are they having to compel the prosecution to provide documents? They're required to share that information with the defense in a timely manner so that they can review these documents and be prepared. So that's one thing that they initially came out with. They had to get these documents from the FBI, and it had to take an order to just get those documents. And at the point, these were draft disclosures in the prosecution. They had just done them 2 weeks ago. So that's going to be an issue for them, because that may possibly press them to delay that trial, which I'm sure they want to move forward. I'm not sure if they have enough time to do that, but they want to move forward. Now, this makes sense, because I'm like, this is out of order. Okay. I'm not seeing them in the order that they should be in. Okay. Now this is making sense. Okay. So let's go back here. Okay. When determining whether to exclude evidence due to late disclosure or non-disclosure, the trial court must weigh the prejudice to the state against the defendant's right to a fair trial. It is error for a trial court to exclude a witness based solely on late disclosure without analyzing whether the state would suffer prejudice from the late disclosure. So I think what Brian Kohberger's attorney is saying, even if he wants to disclose his alibi late, it would be unfair to him. As long as the prosecution still has time to investigate that alibi, they should be fine. There shouldn't be an issue if he waits to give the disclosure. And they're saying that if it's not allowed, it would be an issue. He would suffer from that. Let me keep reading. In addition to weighing the competing interests at stake, the trial court should consider whether less severe remedies would be sufficient for the untimely disclosure or non-disclosure, such as a short continuance, a mistrial, or sanctions against defense counsel before excluding a defense witness. The trial court has an obligation to fashion a sanction which will impress counsel with the importance of responding to discovery requests. Okay. However, when the defendant's discovery violation was willful and designed to facilitate the presentation of fabricated testimony or to impede the state's ability to conduct effective cross-examination or to present rebuttal evidence, exclusion may be a proper remedy, notwithstanding the availability of other sanctions that would prevent prejudice. So what the defense is saying, that if he was trying to withhold his alibi to thwart their timeliness to look into it, to search for witnesses, talk to witnesses, be able to be prepared for court, then yes, that is completely wrong. He should not be doing that, and that's not his intention. He's not trying to fabricate any testimony. He's not trying to stop the state's ability to cross-examine him or present any rebuttal evidence. For example, if he says that he was, and I don't even want to say him, but if a person was to say, I was at the laundromat, but maybe they didn't want to say it immediately, they wanted to wait. They're saying that as long as it's not preventing the state and it's disclosed later, so say the deadline is today and it's disclosed 2 weeks from now, as long as there's time for the state to do a proper review, they can look into it, they can confirm it, and they're able to rebut it if possible, then it should not be an issue if it's coming in late, as long as they still have the ability to look into that. So for example, you can have a continuance or something like that going on, as they said, and that would still give the state, you can do a short continuance, that would still give the state time to look into the alibi. And we should talk about what an alibi is also, okay? Because that's important. We need to know all of our terms, so when we're discussing this, we are prepared. Alibi. An alibi is a claim. This is when it's used as a noun, okay? An alibi is a claim or a piece of evidence that one was elsewhere when an act, especially a criminal one, is alleged to have taken place. If the word alibi is used as a verb, it's offering an excuse or defense for someone, especially by providing an account of their whereabouts at the time of an alleged act. So in his case, we're gonna get into the piece about the alibi, but we want to just make sure we have that foundation. Okay. Now I saw something pop up, so let me just check. Okay, so I don't want to post a comment, but I saw a comment pop up. I saw a person's name come up. I don't want to say their name, but I don't know how to view comments. There's a private chat. Okay, there's nothing there. It says chat with everyone, so I'll just say hi. Okay. So if anything comes up there, okay. Well, I don't even think that involved what I'm on now, so I apologize. I think it was just something that came up. So let's keep going. So now we know what an alibi is. It's basically a statement explaining your whereabouts, right? In his case, he had a deadline that he was supposed to provide a statement. I don't know if he wasn't prepared to do it or if he chose not to do it, but again, courts have allowed the alibi to come later, as long as it's not impeding the state or the prosecution's ability to confirm, to verify it, to check into it, to prepare for a rebuttal. So again, if, for example, someone was to say, hey, I was at the laundromat, then as long as they have time to look into that, confirm it, possibly say, oh, no, you weren't at the laundromat. We have proof that you were somewhere else through witness, through video, whatever testimony. You don't want to set it up where it's making it difficult for the prosecution to look into it and confirm it. So the defense is saying that as long as none of that's going on, we're not trying to fabricate any testimony, we're not lying, we're not trying to impede the prosecution on looking into this. But as long as they have enough time, this should not be an issue. Now, let's continue. Okay, let's keep going. Mr. Kohberger has long had a habit of going for drives alone. Often he would go for drives at night. He did so late on November 12th and into November 13th, 2022. Mr. Kohberger is not claiming to be at a specific location at a specific time. At this time, there is not a specific witness to say precisely where Mr. Kohberger was at each moment of the hours between late night, November 12, 2022, and early morning, November 13, 2022. He was out driving during the late night and early morning hours of November 12th to the 13th, 2022. So let's just stop and take a pause here, right? Now, I want to preface what I'm going to say before I say this part. The expectation when an arrest happens is that the prosecution's responsibility is to put on a case, and that case must place that person at that crime scene. Now, for the press, and I'm not saying the press, but to press for the alibi is as almost as if you're pressing him to detail his whereabouts. Now, this is before trial. So if he wants to use this alibi, he has to provide it before trial. So trial is set for October 2nd. He has to provide the alibi if he's going to use one prior to the trial. And the reason being is because the prosecution has to have time to look into it. Just like if they receive any evidence that can prove his innocence, they have to provide it to the defense. You cannot, it's called exculpatory evidence. If it tends to prove his innocence, they have to share, they have to provide it. And it's kind of similar with the alibi, right? If he wants to use an alibi to say, I was not there, remember the alibi is the whereabouts of a person at the time something happened, right? So if he wants to use this alibi, it has to be done prior to the trial. We're 2 months out, a little bit under 2 months out. That prosecutor needs time to investigate that alibi. Now, coming forward again, now I prefaced it with, if you're going to charge somebody, you better be able to place them there. Place them there, put them there, show through witness, which I don't agree with a lot of witness testimony. It's not reliable, but with the witness, video, some type of surveillance evidence, maybe you can place their car there, or if they were in a group, you have to be able to place them there. So the burden it should not be placed on the defense to say this is where I am and I wasn't there. No, the prosecution's burden is to place the person there, the assailant there. Okay, so let's just like preface that. Now going to what it said, Kohberger is now coming out and saying that there was a habit. He had a habit of taking these drives, and they were alone. So right there, let's stop, pause. In that one sentence, it's like a lot packed in there. He's now disclosing, one, that he had a history of taking long drives. So I'm going to assume that he will be able to demonstrate a pattern, right? If I say I have a history of doing something, I should be able to demonstrate that. For example, if I was a gambler, I should be able to demonstrate going, turning money in, having some gambling losses. If I was someone that played the lottery, I might have a history of buying lottery tickets. Whatever that thing is, and his thing is from his attorney through this motion, he had a habit of going for drives alone. Now let's consider this. Brian Kohberger lived alone, right? He did not have a spouse or a girlfriend that lived with him. He lived in an apartment by himself. So if you think about it, him going out for drives, you can't have another person confirm that as an alibi because he did it alone. But he can create a history, a pattern of doing this if he was doing it enough. And if they've been able to go back and watch his history with his driving or through his phone, they may be able to show that same history as this is his pattern. I know a few people during COVID, because they couldn't really get out and go anywhere. They were tired of being in the house. They would go for drives. Me personally, that's not my thing. I'm not going to go for a drive. I'm definitely not going for a drive at night with the price of gas being, $3.50 a gallon. That's not going to happen for me. But I have heard of other people going for a drive. I know a few people with small kids to help the kids kind of like fall asleep. If they were cranky, they would put them in the car, just kind of like quietly drive them around. I didn't have those issues raising my daughter when she was little, and I still would not personally take her out into the dark at night. I just wouldn't do that. But some people, they do this. But if he can show a history, a pattern of doing that through his phone or through the car brain records, I'm calling them car brain records, but you know what I mean, like the maps driving that's installed in a lot of cars. He may be able to demonstrate that. I don't know. But I hope so, because that would help kind of demonstrate this activity on the evening prior to the murders, if he did that late at night into the next day. Now, how long was the drive? Was it 1 hour? Was it 2 hours? What time was it? Now, he's not being specific. Here it says often he would go for drives at night. Now, maybe he's going for drives at night because if he's working in the daytime or going to school in the daytime, maybe where he kind of decompresses, sits down, kind of unloads, clears his mind is at night. Because during the day, you're busy, you're working, you just maybe not have the time. And this is where he has the quiet. So I'm just thinking possibly what he can be thinking. So they're saying that on late November 12th, this is what he did. And he's saying that he's not claiming to be anywhere specifically or at a specific time. And I think he's kind of leaving this kind of broad and open because it's not like they had a preliminary hearing where a witness was put on and he could cross-examine them, question them. So if he's driving around, maybe there's a certain path that he took that day that I don't know if he could recall. I mean, I would hope that he could go back in his mind since he was arrested about 5-6 weeks later. I hope that he can go back in his mind to that particular night and kind of recall his habits that he did. I don't know, but maybe the phone will, or maybe if the car has a record of showing the history of driving, that could bring back to his memory, or maybe even traffic video cam. In a lot of areas, there's cameras that pick up license plates, cars, businesses, ring cameras that could show the path that he was on. If the prosecutor has that kind of surveillance information to show the path that he took and what time. Right now, the murder time has been moved between about 4 a.m. and 4:30 a.m. Now, can we know that he was still out at that time? Because he started into that Saturday leading into the Sunday. So what time was he, if he can recall, out driving? Was it 1 hour, 2 hours, 3 hours? I mean, I could get pretty far in 3 hours. But if he's looping or going in a circle or has a certain path or certain neighborhoods he likes to drive in, for example, during the holidays, they have like some areas that have the beautiful Christmas lights. I'm sure some people may want to go and detour and look at those lights. Or during Halloween, you have communities that really go big. You might want to go and look at those Halloween decorations. I don't know, but that will be interesting to hear more details. But he's saying he's not getting specific. No one has said anything because there was no preliminary hearing. So of course we don't know what potential witnesses would say, or if they're trying to place him at 1122 King Road. We don't know, but that's something that he is stating in here. So he's saying that he was out and he was driving. Okay, let's move on from there. So the next paragraph is, counsel for Mr. Kohberger is aware that case law broadens the definition of alibi with the statutory requirement of a specific location to more broadly include disclosure of information that tends to state the person claiming alibi was at a place other than the location of an offense. Mr. Kohberger has complied to the extent possible at this time. So what the defense is saying is the prosecution expectation is that it's going to be a specific location. So, for example, I gave the laundromat. So that's a specific location, address. The prosecution will be able to go in, see if there's cameras, see if they can figure out who was there that night. If there's any eyewitnesses, they can solicit the public to say, hey, anybody was there during these hours, please contact the police, please contact us. You know, you could be a potential witness, for example. You could go and canvass the area, see if there's any cameras that lead to that area, all of those things. So the defense is acknowledging that in this instance, they don't have a specific location because of the movement. So the driving through. Now, what he could possibly provide is maybe more detail, maybe what path he took. I don't know how many hours it was. I honestly wouldn't be able to recall everywhere if it was for an extended period. If it was probably more than 30 minutes, that would be difficult. Unless he drives the same path. If this is a habit, he may go to maybe where there's a riverfront, or if there's a beautiful park, if there's a butterfly house, if there's an area where boats are, whatever his interest is, I don't know, but that may be something that he can provide to be more specific, like this is the path that I take to go to look at this or view that, and go from there. So, but right now they're saying that this is what they have to offer because of the driving action. So that also would correspond to the prosecution getting the video of the car, his vehicle, or vehicle similar to his, because I don't want to say it's his vehicle, because I'm sure there's thousands of white four-door cars, similar size, design. They may be able to zone in. Some states have license plate readers and they know that's them. Or if they're trying to zoom in on the driver or look for cars that don't have a passenger, I don't know their capabilities. I don't know how many cameras they have. Some cities have a lot. And then they know where he lives. So his apartment, they could really track the cameras that were on a path from his apartment and then leading outward and seeing where the path he traveled, if they're picking up white vehicles during the time of the murder. So maybe if they say the murders was from 4 a.m. to 4:30 a.m., maybe they want to take a look back, maybe starting at midnight, just to see prior to, and maybe 10 a.m., just to give it a nice opening, get as many video surveillances to see what was the path. Was he alone? Can they, peg his car, his license plate, him in there? At night, it'd probably be pretty hard to see, but they do have some great technology now. They can really, really zoom in on a face. So we'll see. I'm sure we will find out more, right? Okay, so let's keep going. Corroboration of Brian Kohberger not being at 1122 King may be brought out through cross-examination of the state's witnesses. At this time, Mr. Kohberger cannot be more specific. The analysis is underway. The defense has been diligently working to analyze relevant discovery materials and conduct its own investigation. Notably, the defense has to obtain a court order to receive relevant discovery materials. That delay hampers the defense investigation. Okay, so it's like a mix in this paragraph. Initially, they're saying that the corroboration of Mr. Kohberger's alibi, it could come for him not being at 1122 King Road, may be brought out through expert witness presentation. So he's saying that an expert witness can testify to his whereabouts, and this could be the technology piece. Someone that does mapping, someone that can go and see the history in the cell phone, the history of the car, the location of the car, any video surveillance. That could be traffic lights, that could be any home interior cameras. I know NASA has cameras that they can look down and see. I don't know if they could elicit some help from them to see if they can shed any light on what happened at 1122 King Road. Can they see? Is there any recording? Is any neighbors in the area of 1122 King Road? Did they have any video surveillance? They're saying that through expert witness, they may be able to get confirmation, not just in the alibi statement saying that he was driving, but also that it wasn't his vehicle that's found on these cameras, these videos, that's not his vehicle, and it would be through expert witnesses. So they're going to take all of that evidence and have an expert review it, and they may be able to shed some light to support what Mr. Kohberger is saying. But they're also saying that to obtain these records and materials so that they can conduct their own independent investigation separate from the prosecution, that they're having to go through these hoops of getting a court order. And this is delaying their investigation, is slowing the defense down and looking to what has happened. And I wonder if they're trying to bring up, this is about the third time I read this in these short paragraphs. I wonder if the defense is alluding to maybe a violation of his rights to have a speedy trial, because you can't on the front end delay providing evidence, but then on the back end want to have his speedy trial not occur by withholding the evidence and making them press for evidence and get court orders for everything, because you're kind of creating the problem. I'm not sure if that's what's happening in this case in particular. I don't know if it's just a voluminous amount. It's just so much records and police interviews and video and tips and it was such a huge case that I cannot imagine the amount of material to gather it, to share it timely. Now, they did arrest Kohberger. This has been 7 solid months. Um, this was back in December. So just gathering that information and sharing it with his counsel, it has to be a huge amount of material. So let's continue to read. It says the right to offer the testimony of witnesses and to compel their attendance if necessary is in plain terms the right to present a defense, the right to present the defendant's version of the facts as well as the prosecution's to the jury so it may decide where the truth lies. Just as an accused has right to confront the prosecution's witness for the purposes of challenging their testimony, he has the right to present his own witnesses to establish a defense. This right is a fundamental element of due process of law. And Kohberger's attorney, she's absolutely right. That's what I was saying. It sounds like she's kind of bringing up some issues. Excuse me, where they want to be prepared. They want to be prepared when they go to trial. They want to be prepared with the witnesses to be able to cross-examine them and to put on their own witnesses. And that will be determined somewhat through the evidence that's shared, through the records, through the materials, through the video. You want to be able to look into that in a way just as well as the prosecutor. So you don't want to violate his right to have that information. They should not have to be going through getting all these court orders for what sounds like exculpatory evidence. Exculpatory evidence is evidence that could tend to prove that the assailant is not guilty. So you can't withhold that, and having them to have to keep them going to court to gain these are important information, videos, any testimony, any police interviews. All of that is important. They need those records. So let's keep going. The defense acknowledges a vast amount of discovery has been provided. I just said that. So yeah, it's probably a ton of material, a ton of documents, a ton of video. I'm surprised that his family, I wonder if they're going to hire additional attorneys to just help and prepare and actually prepare for the trial also. That's a ton of material. You would need a team to review all these documents. So this is going to be very challenging for both the prosecution and the defense to do effective jobs and have this trial in less than 2 months. I'm not going to say it's not possible. I know that in the state of Idaho, they can request 2 continuances, really, just to give them more time, 2 30-day continuances. So I really don't think it's going to happen in October. I've always said next year because this is a lot. You have some holidays coming up, a new year. So if they started in January, February, that would give both the prosecution and the defense some time to compare, to investigate, to gather witnesses, to gather their testimony, to do some of the technology things, so that they will have that prepared also. Okay, so let's keep going. Okay, so the defense acknowledges a vast amount of discovery has been provided. Discovery is received on a nearly weekly basis. So they're giving them information. It's a lot. It's a volume. It's a huge case, and you have four victims. So you have a huge crime scene. So you have the house. Those are 3 floors. Then you have 4 victims. So you have each person's background to investigate, each person's family, friends, job. You have to filter through all of these tips. You have to go and interview people. You have to look at the evidence. And honestly, the crime scene is in 2 parts of the house. So technically it's contained in the house. But this is also a case that's going to involve a lot of video and hours of video from different parts of that community, the city, the highways, the traffic. It's a lot of material. So I can only imagine how difficult and challenging this is going to be. So both the prosecution and the defense, I'm sure they probably have at least 3 to 5 lawyers each. They would need at least that. And it's still going to be a lot. The defense reviews and acts on the discovery as quickly as possible, including making appropriate supplemental requests for discovery. The state's motion is an attempt to force the defense to open his work product files and let the state peek inside. The defense has stated all that can firmly be stated at this time. This is not trial by ambush from the defense. So the defense is saying they're not trying to ambush the prosecutor at trial. They're not trying to surprise them, with anything that hasn't been revealed. This is the defense requesting information as quickly as possible, yet in some instances face the delay of requesting a court order to obtain information. There it is again, that she's alleging that the prosecution is delaying providing documents and that they have to keep going through the process of getting a court order to obtain the information that should be submitted without having to go through all these steps. The state continually uses those opportunities to attempt to force a waiver of speedy trial. So the defense is believing that these actions by the prosecutor is so that Kohberger does not have the speedy trial, that he waives his right to the speedy trial, because the trial right now is set for October the 2nd. That is a decision left to Mr. Kohberger. Mr. Kohberger, yeah, that's his right. If he wants to waive his right to a speedy trial, he can. That would be totally up to him. Okay. The court may exempt Mr. Kohberger from further inquiry. Mr. Kohberger requests such an exception at this time. Continued inquiry at this juncture delves into his case investigation as well as protected work product. In support of an exemption, Mr. Kohberger is prepared to provide further detail in an ex parte hearing with the court. So, okay, this is dated August 2nd, 2023. So what the defense is saying is that they will have a separate ex parte hearing with the court to explain further his alibi. Okay, I'm not sure if that's going to happen because, again, the ex parte hearing will not include the other party. And the other party in this case is the prosecution. So the defense is saying that they're willing to provide additional information, but they will only do it with the court. So I'm not sure if the judge is going to do that. That may have some other implications. If the judge is aware of things that the prosecution isn't aware of, I wonder if that could cause a mistrial. I don't want to give too many of my thoughts out, but my mind would go to something like, would that be an issue later? I'm not sure, but I want to read this article that CNN wrote about what we just discussed in that motion, and then we'll be all set. Okay, so. I shared this on my page, and I want to read it because it kind of picks up right what we just discussed. And this was Friday, August the 4th. The name of the article is "Suspect in Idaho Killings Will Use an Alibi Defense, but Doesn't Claim to Have Been at a Specific Location," attorneys say. Okay. This is from CNN. Attorneys for a man accused of killing 4 University of Idaho students last year say they will be using an alibi defense, but do not have one specific location for where he was. They said in a court document filed Wednesday. The defense attorneys for Brian Kohberger made the statements in an objection to prosecutors' motion from last week to compel Kohberger to share the exact location of his alibi and the names of witnesses who could testify to his location. So again, they're saying that they don't really have an exact location, and that's the standard for the alibi, that you give a specific location, right? They're saying that they don't have that because he was driving, he was in motion, and he drove alone, he was by himself, and he had a pattern of doing it, right? So how are you going to get specific witnesses or a specific location when he's driving? So the defense is saying, well, when we put on the other parts of our defense, this may come out. We may be able to find support in other ways through these other means, through expert witnesses, through testimony, through video, to support what we're saying. Kohberger faces 4 counts of first-degree murder in the November 13th deaths of 21-year-old Kaylee Goncalves and Madison Mogan and 20-year-old Zaina Kernodle and Ethan Chapman, who were fatally stabbed in an off-campus home in Moscow, Idaho. A not guilty plea has been entered on his behalf, and his trial is set for October. Statements by a surviving witness and other evidence leads investigators to believe the killings happened between 4 a.m. and 4:25 a.m., according to court documents. Mr. Kohberger has long had a habit of going for drives alone. His attorney's Wednesday filing reads. Often he would go for drives at night. He did so late on November 12th and into November 13th, 2022. Mr. Kohberger is not claiming to be at a specific location at a specific time. At this time, there is not a specific witness to say precisely where Mr. Kohberger was at each moment of the hours between late night, November 12th, 2022, and early morning, November 13th, 2022. He was out driving during the late night and early morning hours of November 12th through 13th, 2022. The attorneys say they recognize the use of an alibi requires a specific location, but that Kohberger has complied to the extent possible at this time. Their objection says, corroborating evidence may come from cross-examination of state's witnesses. Corroborating evidence may come from presentation of defense experts. Mr. Kohberger is aware of and will comply with his continuing duty to disclose information, the objection says. His attorneys asked in the filing for the court to exempt Kohberger from further inquiry and said he is prepared to provide further detail in an ex parte hearing with the court. In asking for the defense to provide alibi information last week, prosecutors had noted the trial is about 2 months away. If the defense intends to rely on an alibi, it is essential that they be required to provide prompt notice so the state can fulfill its obligations under Idaho Code to investigate and respond to the notice of alibi. Any further delays will substantially prejudice the state's rights, the prosecutor's motion reads. Due to a wide-ranging gag order, prosecutors, defense lawyers, and attorneys for victims' families and witnesses are prohibited from saying anything publicly aside from what is already in the public record. Kohberger was a graduate student at Washington State University near the Idaho state line and less than 10 miles from where the stabbings happened. He was arrested 7 weeks after the killings at his parents' house in Pennsylvania. He has been in police custody since then and is being held without bail. Prosecutors will seek the death penalty according to court documents. Let me just say this. I'll finish with this. I'm going to read that one more time. He has been in police custody since then and is being held without bail. Kohberger has been in police custody since December of 2022, right? So a solid 7 months. This is why people do not like the grand jury indictment process. The grand jury is secret, so you don't know what's happening. You're not able to put up a defense. You're not able to cross-examine, okay? And then when you are indicted and arrested, you're like in this case, he's been in jail for 7 months since last December, right? So what if, let's just give an example. So we know he's innocent until proven guilty, right? But let's just give a little example of What if Kohberger is innocent? Think about all of the things that have happened to him. He did not get an opportunity to cross-examine any witnesses. He did not get an opportunity to have any say in the process because instead of having the preliminary hearing, the prosecutor went for the grand jury, which has the standard of just probable cause. Do you believe that this happened, that this person committed this act? So the standard is lower. But not just that. Going to the grand jury, the burden was a lot lower for the prosecutor. So although you're charging him with 4 murders and you're seeking the death penalty, the standard for that should be a lot higher. But his life has been uprooted, right? He probably lost his job. If he was in school, his apartment, if he had any future plans, he could have continued on with his life and went and put up a defense if he had a preliminary hearing. He could put on witnesses. He could be a witness. He could cross-examine people. He would be able to find evidence that he could put on. He could put on his alibi. That would have been a fairness. A lot of people don't support the grand jury anymore, and they're moving away from it because they're not getting that chance. And in his case, he's been charged with 4 murders. So he hasn't been free. He's been in prison. Every aspect of his life has changed. And if we just think about it, if he is innocent, this has pretty much, the word hurt wouldn't even describe what has happened to him. His family, his career, his life, his image has been all over the world. He has been deemed in public opinion, a murderer. He has been deemed a murderer. So in just considering that, most people now, they want the states to require a preliminary hearing so that it can have a balance where the prosecutor and the defense can both put on evidence. And if there's determined to be enough evidence that that person should be held over for trial, then that happens, right? But when there's a grand jury indictment, the grand jury is in secret. So you don't even know what's happening. And then you can't put up any kind of defense. You can't cross-examine. You don't even hear what evidence they're using, what evidence they gather, what witnesses, what video. You don't hear any of that. You have to then wait for, if you're indicted, to then be arrested and then go through the process of going to trial and then, going through that evidence versus at the preliminary hearing, both the prosecutor and the state will both put on like many cases. So that's why a lot of people now, and across these different states, they want to have the preliminary hearings now. Is it more work for the prosecutor? You could say yes, but in reality, they already are doing the work, right? Because they know if this is the person they believe committed a crime, they're already working towards going to trial, unless that person doesn't fight it and just pleads guilty, right? For 4 murders, more than likely you're gonna put up some kind of defense. But I think it's a lot easier for the prosecutor. They don't have to schedule everything. They don't have to bring the police in. They don't have to bring the medical examiner in. They don't have to bring the victim's family. They don't have to bring witnesses, In this case, it was a very heinous crime and you have 2 surviving roommates. So you don't want to put them through it and put them on the stand in a preliminary hearing, but you can put them on the stand in the grand jury indictment because there's not going to be a defense that you have to worry about cross-examining them, that they're going to be feeling uncomfortable if they feel this is the killer. Now they're testifying in front of the killer. Now we have to look ahead. Trial is coming up, right? So the same experiences are going to happen where if these are the 2 surviving roommates unharmed, are they going to testify? Or are you still going to shield them and they're not going to testify? You're going to not necessarily use them at all, their testimony at all. You're going to rely on these other things. You're going to rely on the video. You're going to rely on the sheath, the touch DNA on the sheath. Maybe you have some other witness. Maybe you're going to use the the cell phone records, the cell phone towers. I don't know. I don't know what the prosecution is thinking, but I think the prosecution, in that little twist, they did it because it benefited them. They could get to the same result, which is we don't have to do the preliminary and we can do the grand jury indictment. Our standard will be lower. We don't have to worry about what the defense is or isn't doing or what they do or do not know. We can put our case on. We can try that. We can see how our witnesses do. And then we're prepping them for the big trial that comes up, you know, in October or whenever, because I don't think they'll be ready in October. That's less than 2 minutes, but we'll see, right? We'll see. We'll keep watching. We'll keep our eyes on this case because this is really it's a huge case. It's like the case of the century. It's a big one. And people are interested and they're talking about it and they want to know. So I hope you enjoyed this video. I hope you check out future videos. I'm in trouble on Facebook, so I'll have to do my videos on here. And hopefully if it turns out okay, I can keep doing them on here. So thank you for checking out this video. Please check out some of the other videos, especially the video on the Ohio missing children. There's a lot of missing kids in Ohio. It's like a really, really big deal. And that's something that we can do about that. You know, we need to make some changes in the state of that information is getting put out publicly for those missing kids because a lot of them don't have pictures, and that's really a big thing because people remember faces. They may not remember necessarily the name or the city where they're from, but they'll remember a picture. So we definitely need to work on that. But if we could just watch that video, share that information, there's some resources in there about the FBI, and if you need resources, if you know anybody that's being trafficked or they need some support, that's definitely a great video to watch. So I want you guys to, look at some other videos too, but, we gotta talk about the Idaho Force sometimes. So I'll probably be back on them unless something really big happens. That's new information that needs to be talked about. I'll let this rest for a while until we get closer to the trial of October 2nd, which I don't think is going to happen. We'll see. But I'm going to be doing a case involving the FBI, a recent abduction. So that's coming soon. I have a lot of information. I just have to put it together. So be looking for that. And I think right now, I think that's really the only case that I have outstanding that I have not put out, but I have some information on. So I hope you enjoyed this video. I hope to see you in a future video. I want you to always take care of yourself, your family. Be smart, be savvy, be safe, okay? Take care, and thanks for watching this video. Bye.